Good morning, all of you. How is everybody doing? I hope the students have joined for today's class. Is everybody ready for class for today? So, in the previous class, we had taken up the chapter, the Arbitration and Conciliation Act. So, around 60% of that was already completed in the previous class, and the remaining that we would be completing today. Now, before we jump on to the remaining provisions or remaining part of your syllabus, I would really like to entertain the queries that students would have after studying the chapter or after re-revising what we had discussed. So it would be better that we first discuss the queries from the previous class for around 10-15 minutes and then start with today's class. So I'm requesting all the students to share all the queries that they have in the chat box. I will take the queries one by one from all of you. So you can start putting your queries in the chat box and I will take it up one by one. Okay. So I'm waiting for students to respond to it. I'm sure after going through the study material for Arbitration and Conciliation Act, all of you would have some confusion, some queries that you would want me to clarify for you. So please share your queries. There is nothing wrong in having doubts or concerns over a chapter. So it is better that we discuss this right here so that later on you do not face any problem. I really want to help you in this way that after this class, you don't need to invest too much of time on this chapter, because the weightage is not very high. Around 3 to 4 marks question comes from this chapter, but it is extremely theoretical chapter. So 3-4 marks is like just easy marks that you can get or easily attempt these questions. And even you don't have to divulge into too much of details into sections and all. Basics, understandings, basic provisions, and you're good to go. So let me know if you have any queries from the previous class that we did. We have a lot of students who have joined in, but nobody wants to raise any queries. Is that the case? Or nobody got time to read what we had discussed in the previous class? Do you want me to quickly revise on what we discussed in the previous class? Guys, please be interactive, because till you interact with me, see, we are not sitting in a physical class where students are in front of me and I'm able to make out what's going on in their heads. So I want my students to be interacting. You have the provision of interacting with faculties on the chat box. This is why we have live video lectures, right? So there's a difference between live classes and the recorded ones. So these live classes are arranged where we can have interactive sessions where students can directly reach out to faculties, have their questions answered, attend the class, keep on preparing along with the class. This is why we have live class. Else we would have only the provisions for the recorded lectures. Why wake up a faculty in the morning also? Hi Sumit, good morning. Okay, so let us quickly rewind what we had discussed in the previous class. So in the previous class, the first area that we touched upon was the concept of alternate methods of dispute resolution. So we said that yes, there is a litigation system which is governed by CPC and CRPC. Still, due to increase in backlogs and pendency of cases in the courts, with the increase in burdens and vacancies for judges in the court, there was a need for a alternate method of dispute resolution which could give a speedy justice, right? So we know that a delay in justice is the justice denied. So in order to ensure speedy trial, speedy remedy, we needed alternate methods of dispute resolution. Now, we know that the right to speedy trial or right to justice is also a part of our fundamental rights, which is very much enshrined in the Constitution of India. So in order to support that mandate, the Parliament of India recognized few forms of alternate methods of dispute resolution. Now, what were these forms? There were Lok Adalats, there were arbitration, mediation, conciliation, negotiation. So these are what? Recognized forms of alternate methods of dispute resolution. Now, the question arises, are these something new that has come up all of a sudden, or it has already been in existence? So the fact remains that these have already been in existence since very, very long time. So there was a panchayat system that has always existed in India. There were systems where the elders of the house used to come together in order to resolve disputes. So these alternate modes of dispute resolution are nothing new to our country. Now, what are the advantages of these alternate methods of dispute resolution? The costs are lower, the flexibility is greater, there is a higher amount of confidentiality, greater likelihood of settlement, quick settlement, the choice of forum, the choice of solution, everything is available. Plus, there is a lesser chance that the parties to the dispute will develop enmity towards each other. However, there are certain disadvantages also because it requires cooperation from both the parties. There's also some power imbalances between the parties. There's lower possibility of interim measures, and sometimes the enforcement could become a challenge. However, the new Arbitration and Conciliation Act has very much dealt with the problem of enforcement, right? Now, coming to the arbitration as such. So if you talk about the legal framework, arbitration and conciliation has been provided for in the Arbitration and Conciliation Act 1996. The Lok Adalats get their recognition from the Legal Service Authority Act along with the IPC, Section 89 of the CPC. I'm sorry, not IPC, CPC, which is the Civil Procedure Code. Now, the mediation is a form of OADR, which does not have a specified defined legal framework as of now. But a draft bill has already been introduced in the Parliament for the same purpose, for the consultation of draft bill has been introduced for consultation of the public. So we can expect a legislation on mediation as well. Now, coming to the Arbitration and Conciliation Act 1996. So this act provides for certain definition, but there are one important point that I want to remind here. When we talk about jurisdiction of courts, and it is about just the jurisdiction of court for interfering in the arbitration. So there, the judicial authority for domestic arbitration is the domestic court and the high court, original side, and for the international commercial arbitration is the high court and it's the high court, correct? Now, coming to the right of appointment of arbitrator. So when there is a need for intervention of court where the arbitrator is not being appointed, then the courts can intervene and the authority lies with the high court when it is a domestic arbitration and the Supreme Court when it is a international arbitration. Even though there is minimal scope for intervention of courts in arbitral proceedings, but there can be situations where the parties are not able to appoint an arbitrator which is acceptable to both the parties to the dispute. In that case, any of the parties can reach out to the court. If it is a domestic arbitration, to whom they will go? They will go to the high court. If the arbitration is an international arbitration, to whom they will go? They will go to the Supreme Court. So the appointment of arbitrator is either done by the High Court or the Supreme Court, depending on what kind of arbitration it is. Is that clear? Is this clear? Now, talking about certain key features of the arbitration. So one of the most important requirement of arbitration was the arbitration agreement. And when we were talking about arbitration agreement, there were few important requirements. Firstly, it should be in writing. It should not be vague. There should be consensus ad idem. The place can be decided by the parties on their own. The number of arbitrators can be decided by the parties on their own. Right? All these key features we have already discussed. So as such, in case of arbitration, there is a lot of autonomy that is available to the parties. But if they are not able to decide on their own on the procedure that they want to follow, they can also go for institutional arbitration. So we discussed there were two kinds of arbitration. One was institutional and one was ad hoc arbitration. Institutional arbitration is one when we mention that any dispute arising between the parties in future concerning to this will be submitted to the International Institute of Commercial Arbitration. Let's say it's like that. So what you are submitting, you are saying that it will be resolved by an institution. Those institutions support and assist the entire process of arbitration. Also, when the parties are unable to fulfill the procedure that was specified by them, then also the court has to step in. So once the dispute is referred for arbitration to the arbitral panel, now when I say arbitral panel, arbitral tribunal, it means it could even be one arbitrator or more than one arbitrator. Generally, practically, the number of arbitrators that we get to see is odd number of arbitrators. Even though the law says that the number of arbitrators should be odd, 1, 3, 5, 7, but through a case law, through a judgment of Supreme Court, it was said that there is no foundation that the number of arbitration could not be even. However, practically when you see, you only get to see odd number of arbitrators. Now, once the arbitration is completed, the arbitral award is passed, right? And this award is binding on the parties. Now, another key feature of arbitration was confidentiality. So whatever is discussed in the arbitration proceeding, it remains private, right? Then the arbitral award of foreign nations also could be enforced in India because India is bound by certain international treaties, right? Is this clear? Now, these were the basics that we had discussed. Now, I'm not getting into too much of details on everything that we had discussed, right? These were the key important points that you need to remember. Okay, Abhilash, you can expect a question of 3 to 4 marks from this chapter. In the end of this class, we'll be discussing a lot of questions, the kind of questions that come, right? Original civil jurisdiction means every court has defined set of kind of trials or kind of disputes that they can take. So, you know, High Court is a court of appeal as well. So let's say you went for trial in the lower court, correct? And then there was dissatisfaction pertaining to the orders that were passed to the trial court. What do? You go for an appeal. Where do you go for an appeal? You go for an appeal to the High Court. If you were dissatisfied with the High Court orders, you go for an appeal and you appeal in the Supreme Court. So there is a hierarchy of courts in India. On the top is the Supreme Court, in the middle is the High Court, and in the bottom is the district courts or the lower courts. Now, what happens when you appeal in the High Court? It is the appellate jurisdiction of High Court, correct? But there are a lot of cases that are for the first hand filed in the High Court itself. So that is called the original jurisdiction. So if you talk about Delhi High Court, if there is a commercial dispute and it amounts to more than 2 crore rupees, it will be directly filed to the High Court and not to the lower court. This is what is meant by the civil jurisdiction. Is that clear? Jay, is that clear to you? Is this clear, Jay? Please answer me in the chat box, yes or no, when I address your queries, because it becomes really difficult for me to figure out whether I was able to explain the concept to you or your confusion is cleared or not. Because if it is not clear, I'll re-explain it to you. So is it clear, Jay? Okay, I'm assuming that it is clear. Now, your next question was the difference between arbitration and conciliation. The difference between arbitration and conciliation, I'll take up once I explain the conciliation part to you as well. Before that, it makes no sense because I haven't explained conciliation to you. Arbitration, we are almost done with. There are a few topics that are left with that we are going to take up now. Okay, any other questions on this part? Thank you, Jay. Thank you for responding. Any other questions on the key areas that we had discussed in the previous class? Also, one thing that I want to revise for you guys is who can be an arbitrator. So there is no specific qualification required to be an arbitrator. Any person who is capable of entering into a contract can be an arbitrator. So thus, he should be of sound mind. He should have attained the age of majority. These are the key requirements. Now, the parties are as such free to decide on the number of arbitrators and lay down the procedure. So the most common procedures that you see, that parties say that the arbitration will be carried out by a sole arbitrator, and the sole arbitrator will be jointly appointed by both the parties or mutually appointed. Now, there is a lot of autonomy that has been provided to the parties in case of arbitration. So there can be arbitration clauses where parties pre-hand provide a list of arbitrators or pre-hand mention the name of arbitrators. There can be arbitration clauses where the parties define the expertise or the skills or the experience required in an arbitrator. So there are a lot of customization that is available. They can choose the place of arbitration, the seat of arbitration. They can choose to which law they want themselves to be subjected to. They can choose courts or which courts of which area will have jurisdiction, right? So all these things can be customized. However, there can be situations where parties are unable to decide on the procedure for appointment of an arbitrator, right? In that case, where the arbitration clause says that only one arbitrator is to be appointed, then that one arbitrator has to be appointed by the mutual consent. Now, how does this happen? Now, let's say there's a dispute between me and Mr. A. So the matter has to be decided through arbitration. Let's say I submitted 4 names to Mr. A. Mr. A does not agree to it. He sends back another 5 names to me. That is not agreeable to me. And this back and forth continues for 30 days and I'm unable to appoint the arbitrator. In that case, any of the party will reach out to the court who will appoint an arbitrator. And once the arbitrator is appointed by the court, it is final. You cannot go and complain or request for change in arbitrator. Another thing, when the court is appointing the arbitrator, the court will ensure that the requirements, the expertise that is needed, the qualification that is needed is present in that arbitrator. Also, when the court is appointing the arbitrator or when the parties also appoint the arbitrator, they take a declaration from arbitrator, declaration as to biasness and impartiality, right? Like the arbitrator will have to make declaration if he is in any way associated with either of the parties which can raise concerns over being impartial, correct? So those declarations have to be made. Now that was one scenario where one arbitrator has to be appointed. However, there can be a situation where the arbitration clause provides for 3 arbitrators. So in that case, both the parties have to appoint 1 arbitrator each, and those 2 arbitrators that are appointed, they will mutually appoint a 3rd arbitrator. Now, supposedly, these 2 arbitrators who were appointed, they are not able to mutually appoint a 3rd arbitrator within 30 days of their appointment. then what will happen? Who will you go to the? You will go to the court. Now the question arises, which court? If it is a domestic arbitration, you will go to the High Court. If it is an international arbitration, you will go to the Supreme Court, right? Similarly, if the number of arbitrators provided for is 5, 2 each will appointed by each of the parties, then they 4 together will appoint a 5th arbitrator. This is what is the procedure generally prescribed for. So either the parties can decide their own procedure. If they are not able to decide their own procedure, the procedure that has been laid down in the Arbitration Act is followed. Is this clear? Okay, Abhilash is asking me, ma'am, if the dispute is not resolved by arbitrator, then what is the alternative? And party is not satisfied with the decision. If the party is dissatisfied with the decision, there are the grounds of appeal available under section 34. But you cannot appeal against the order of every order of arbitral award. There are only certain grounds, like the arbitrator was biased, he was impartial. So there are very limited ground, or the due process of law were not followed, principles of natural justice is not followed, right? So the award is arbitrary, or all the disputes were not resolved. So only in those cases you can appeal against the award of arbitral tribunal. As such, it is a final proceeding and it is a binding proceeding. Not for everything you can go to the court. Also remember, there was a need for arbitration so that the burdens on the court are reduced. So if we end up going to the court again and again, it does no good. Now, you are saying if the dispute is not resolved by arbitrator, see, when the arbitrator starts an arbitration proceedings, he has a period of 12 months to decide on the dispute. If for some reason he is not able to decide on the dispute, the matter remains undecided for a period of 12 months, then the parties can go to the court. Is that clear? Is that clear, Abhilash? So we have, now I think it's important that we start with the remaining procedure parts for today's class. We have invested enough time on the previous day's lecture. Are there any other queries? We can take 2-3 minutes more. If there are any queries, I can take 1 or 2 queries more and then start with the next topic. Is there any peculiar section that anybody wants to understand, or there's some confusion? Please let me know if there is any specific topic that any of you want to understand, or there is some confusion in that. So I'm talking about the topics that we took in the previous class, right? Okay. Assuming that there are no more questions and queries, we can proceed with today's class. Okay. Now, in the previous class, we took about appointment of arbitral tribunal. What is an arbitral tribunal? What is the procedure for appointment? And what are the requirements of an arbitral tribunal? That we have already discussed. Now we have to talk about the situations regarding termination, removal, and substitution of arbitral tribunal. So in the previous class, we told you that arbitral tribunal, once appointed by court, he is final, right? But can there be a situation where we require to appoint a new arbitrator, or where there is a requirement for substitution of arbitrator? If yes, how it can be done? What are the procedures? What are the situations? So there can be few scenarios under which an arbitrator is removed. First case is the arbitrator leaves voluntarily. So the question arises, is it permitted for an arbitrator to leave the arbitration in between? Yes, it is very much permitted. So it is like a contract between the parties. It is a private consent-based arrangement. So if the arbitrator wants to discontinue, he cannot be forced to act against his will or continue as an arbitrator. So when the arbitrator leaves voluntarily, there can be a situation where we would require to appoint a new arbitrator. Second situation is when all parties that are involved in the arbitration agree that the arbitrator should be removed. Now, there can be several instances, situations in which the parties would want a particular arbitrator to be removed. Maybe that the parties realize that the arbitrator that they have appointed, he does not have the expertise that is needed for adjudicating upon this dispute, or the arbitrator is not giving sufficient time, enough time, and the arbitral proceedings are getting delayed, right? So in these situations, if all the parties to the arbitration agree that the arbitrator should be removed, in that case also he can be removed. So there's an example that I provided here. For example, a person was appointed as an arbitrator for his expertise as civil engineer. However, the parties during the arbitration find out that his experience was inadequate in construction projects involving large dams. So here the parties could, through a unanimous decision, decide to have another person as an arbitrator. But always remember, the decision has to be unanimous. All the parties need to agree for the removal of the arbitrator. Next situation is by the operation of law. So section 14 provides for a situation where it becomes mandatory for the termination of the arbitrator. So section 14 says the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure, that is by law, de facto, by fact, unable to perform his functions, or for other reasons fails to act without undue delay. So one situation is where by the operation of law or due to certain facts and conditions, he is unable to act or he fails to act without delay. So what is happening? The arbitration proceedings are going very slow. Now the reason behind is either this person himself has got stuck in some kind of legal proceedings or a criminal offense, or he has taken up a new responsibility. Let's say he has become a CEO of a company, which doesn't permit him enough time to be invested in the matter. Second situation is he withdraws from his office voluntarily, or the parties agree to the termination of his mandate. So section 14 says in both these situations, it will become a mandate to terminate the arbitrator and substitute him with a new arbitrator. So the older one will be terminated and the new one will be appointed. Now you will ask, ma'am, how the new one will be appointed? Now when the new one has to be appointed, again the same procedure that has been prescribed will be followed. Is that clear? Also, the mandate of the arbitrator comes to an end when the arbitration process comes to an end. Now, the process of arbitration can come to an end under different situations. First is the final award has been made, that is, the dispute has been adjudicated and a final verdict has been given. Second, the arbitrator was unable to resolve the dispute within 12 months, or when the parties decide they do not want to continue with the arbitration. So if both the parties decide that they don't want to continue with the arbitration, then also the mandate of the arbitrator comes to an end. Now, there can be situations where the court decides that the arbitrator should be removed. So as of now, we saw three situations. One, he voluntarily leaves. Second, parties unanimously decide. And third is by the operation of law. Here, the fourth situation that we are talking about, when the court is deciding that the arbitrator is to be removed. Correct? So, if the possibilities that we discussed above is not there, the arbitrator is working without delay, the parties are satisfied with their performance, etc., everything is fine. But still, if one of the party feels that the arbitrator should not continue, then it could, for reasons of bias, approach the court to remove the arbitrator. So, for reason of bias, they can re-approach the court for the removal of arbitrator. Now, let's say there was a situation where Mr. A was appointed for a dispute between party B and party C. Now, Mr. A had in the past worked with the company B. At the time of appointment of the arbitrator, this Mr. A had already given a disclosure of the same. That is, both the party B and C were aware that Mr. A had worked for party B in the past, and they still decide to appoint him as an arbitrator. Now, for the same reason, can party C approach the court saying that the arbitrator is biased towards party B as he was earlier working for party B? Can he go to the court for the removal of arbitrator for this reason? Can I have the answers on this question? I hope all of you got my question right. Yes, Jay, your answer is right. Anybody else would like to answer this question? I have got answer only from one student. I hope all of you got my question right. So the answer is no. Now, why is it a no? Why can't they go to the court for removal of the arbitrator? Because they made an informed decision. They were well aware of the situation and still they decided to accept it. So they have waived off their right for going to the court. Now, let's take another instance. Now, this Mr. A, who was appointed as an arbitrator, he was seen talking to party B on several instances separately, privately, and he never informed the other party about it. Or he keeps on giving some sort of favors, or he keeps on allowing a lot of time to party B. In that case, can we reach out to the court for biasness? Can we reach out to the court for biasness, for being partial, and request for removal of arbitrator or for termination of the arbitrator? Can one of the parties do that? Yes, they can. Right? Now, let's discuss section 12 a bit in detail. Okay. So section 12 subsection 3 says, an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to his independence or impartiality, or he does not possess the qualifications agreed to by the parties. So if the qualification is missing or there are doubts pertaining to his independence or impartiality, in both the cases, it is permitted to reach out to the court to challenge the appointment of arbitrator. Further, 12.4 says, a party may challenge an arbitrator appointed by him or him whose appointment he has participated only for reasons of which he becomes aware after the appointment has been made. So you cannot reach the court for anything that was known to you prior to the appointment. So whenever the appointment and arbitrator has to be challenged, firstly, the challenge will be made in front of the arbitral tribunal itself, right? So this is one of the situation where arbitrator himself or the tribunal himself is judging a question against his sanctity itself, right? So firstly, the challenge will be made to the arbitral tribunal. But if the party is unsatisfied, they can approach the courts. Now, who will they approach? Where it is a domestic arbitration, they will go to the district court. And if it is a international arbitration, they will go to the high court. Correct? Now, if you look at the examples here, Rahul was a member of a 3-person arbitral tribunal to adjudicate a dispute between Dell Inc., Microsoft, and Intel Corporation. Rahul was appointed by Microsoft. He had on earlier occasion been associated as a software consultant with Microsoft. Now, when the arbitration proceedings were going on 2 occasions, Rahul privately met with Microsoft lawyers and failed to inform either the other arbitrators or parties about the meeting or the contents of the meeting. It was also observed that Rahul adopted an unduly harsh attitude towards representatives of Dell and Intel, all the while remaining extremely friendly with Microsoft representatives and lawyers. So here, the appointment of Rahul can be challenged on grounds of bias. Now, supposedly, Rahul was removed, right? And a new arbitrator has to be appointed. So, again, the original method will be used for the appointment of arbitrator. Is this clear? So, the challenging the appointment of arbitrator or the removal and termination, is this clear, guys? Any confusion in this section? Please let me know if there are any queries here, or we are good to proceed further. Okay, I'm assuming that all of you are good with this and I'm proceeding further on this. Okay, I'm quickly repeating for some students, it is not clear. So we are talking about challenging the appointment of an arbitrator, correct? Is this clear? So we know the arbitrator is appointed by the parties generally. However, can their appointment be challenged? Can there be a situation where the appointment of an arbitrator be challenged? Yes, there are certain situations where the appointment of arbitrator can be challenged, or he can be removed or terminated. Now, the first situation is arbitrator leaves voluntarily. So this is the voluntary where he's, for any reason whatsoever, he leaves the arbitration. If he leaves the arbitration, a new arbitrator will have to be appointed. Whenever new arbitrator is to be appointed, again the same procedure would be followed. Second, the parties who are involved in the arbitration, they agree that the arbitrator should be removed. Okay, is it possible? Yes, it is possible. The parties can, through a unanimous decision, so both parties should agree and remove the arbitrator. For example, a situation where the arbitrator did not have the particular expertise, or the arbitrator was not able to give sufficient time. So the parties can unanimously decide to remove the arbitrator. Second situation is there is a operation of law. So section 14 says, where by the operation of law or by the operation of fact, if the arbitrator is unable to perform his functions or there is an unnecessary delay, in that case he can be removed. Another, it says, it agrees that where the arbitrator quits arbitration voluntarily or the parties agree to the termination of his mandate. So this is what is section 14. So section 14 reconfirms that we were talking about voluntary removal or the unanimous decision of the parties. Now, in another situation, the mandate of arbitrator comes to an end where there is a completion of arbitration proceedings. Now, there can be three situations where the arbitration proceedings come to an end. Firstly, the matter has been adjudicated and the final award is made. Second situation is the arbitration is not completed within 12 months. The award is not made. In the third situation is the parties decide that do not want to proceed with the arbitration. In that case also, the mandate of the arbitrator will come to an end. Correct? Now, the fourth situation is where the court decides that the arbitrator should be removed. So that has been provided in section 12 and 13. Now, if one of the party feels that there is some sort of biasness or impartiality, they can reach out to the court for removal of the arbitrator. But they can only reach out to the court for circumstances or situation or facts or reason that they have come to know only after the appointment of arbitrator. Anything that is in pre-knowledge, for that reason, you cannot reach out to the court. So if something new has come to your knowledge, you see that the arbitrator is behaving impartial and things like that. In that case, you can challenge the appointment of arbitrator in the court. Now, the question arises, how would you challenge the appointment of arbitrator? Firstly, you will put your disputes of biasness or impartiality to the arbitral tribunal itself. If the arbitral tribunal makes a decision on that, you are satisfied, good enough. If you are dissatisfied, you go to the court. Which court do you go? Where it is a domestic arbitration, you go to the district court. Where it is an international arbitration, you go to the high court. Is that clear? Is it clear now? The facto means by facts and the jure means by law. Jure is law. Is this clear? The jure means having a rightful entertainment by the operation of law, by right, correct? That is what is meant by the jure. So the jure is also a Latin terms. And the facto means something that is true in facts, by the facts of it, by the true facts. This is what is. Is that clear, Jay? Abhilash, challenging the appointment of arbitrator is clear. Challenging and termination. So you need to understand termination of arbitrator is different from challenging an arbitrator. Termination happens when the arbitrator himself leaves the arbitration, or the proceedings come to an end, or both the parties unanimously decide that he needs to be terminated or substituted by the new arbitrator. But the challenging happens only when one of the parties aggrieved. Then they challenge their the appointment of arbitrator in the court of law. So you need to understand this fine line there. Okay. Okay. Perfect. Now, coming to the arbitral award. So, once the dispute is adjudicated, the arbitral tribunal adjudicates upon the disputes, they come to a conclusion. So, this conclusive determination to the questions, to the issues, to the disputes that were put forward before the arbitral tribunal is called the arbitral award, right? Now, arbitral award as such is final and binding upon the parties, right? We always know that it is final and binding upon the parties. So it is like a decision that is given by the arbitral tribunal on the various issues or disputes that were raised by the parties and placed before the arbitral tribunal. This disputes, after it has been adjudicated, the conclusion is communicated to the parties. Now, there are certain general principles of arbitral awards that we need to remember, right? Now, the first thing is only a party to the arbitration can challenge the arbitral award. An outsider cannot challenge an arbitral award. So let's say there was a dispute between Microsoft, Intel, and Dell. So in that case, can Xiaomi challenge the arbitral award? So an arbitral award that was passed in a dispute between Dell, Microsoft, and Intel, can Xiaomi challenge that arbitral award? Is it possible? Possible? Please answer. No, Xiaomi cannot, because it is only the parties to the arbitration who can challenge the arbitral award. Okay. Now, the question arises, to whom you make the challenge. So, the challenge can be made to the district court and high court for domestic arbitration, and high court only for international commercial arbitration. Now, what is the timeline within which the challenge has to be made? It can be made within 3 months of the date when the award was communicated, and that period can be extended for a further of 30 days. So 3 months plus 30 days is the maximum duration that is applicable. Correct? Now, what happens when an arbitral award is challenged in the court of law? Either the court will set aside the arbitral award and the award will lose all its value, or it will confirm the arbitral award that it will remain enforceable. Third is modify. So some parts of arbitral awards may lose value or the changes are made, thereby saving it from set aside. And fourth is remit the arbitral award. The court will say that the arbitral award is being sent back to the tribunal for rectification, failing which it will be set aside. So these are the 4 consequences of challenging an arbitral award to the court. Either it will be set aside, or it will be confirmed, or it will be modified, or it will be remitted back to the arbitral tribunal. Correct? Next thing is enforcement. Now, where an application to set aside an arbitral award has expired, or where such application was made but it was rejected, then the award can be enforced. And as such, there is no automatic stay on enforcement. So a party who is challenging an arbitral award, he also makes a application for a stay on the enforcement of arbitral award. Only when he will make an application for stay, then the court will decide, depending on the conditions he thinks fit, he might grant stay on the operation of such award for reasons to be recorded in writing. Correct? But there can be situations where the court is sure that something illegal has happened or something like that. In that case, they can ask for unconditional stay on the enforcement of the award. Correct? Now let's quickly read section 36, which talks about enforcement. It will give you a better clarity on enforcement. So section 36 says, where the time for making an application to set aside the arbitral award under section 34 has expired. What is the timeline for what is the timeline for setting aside an arbitral award, for making an application to court for setting aside an arbitral award? Please tell me, I just told you. What is the timeline for making an application to the court for setting aside an arbitral award? Answers, guys, I just told you about it. 3 months plus 1 month of extension on permission of court. So 1 month of extension is not a mandate. It is a discretion of the court if it wants to give a 1 month extension or not. It cannot be a mandate thing, correct? Now, section 36 says, where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Civil Procedure Code in the same manner as if it were a decree of the court. So how it is treated? It is treated as the decree of the court. Just the way the decree of the court would be enforced, similarly, the arbitral award is enforced. Now, subsection 2 says, where an application to set aside the arbitral award has been filed in the court under section 34, the filing of such an application shall not by itself render that award unenforceable unless the court grants an order of stay of the operation of the said arbitral award in accordance with the provision of subsection 3 on a separate application made for that purpose. So what do attorneys do? Whenever they put an application for challenging the arbitral award, they also put a parallel application for getting a stay on the enforcement of the arbitral award. Now, subsection 3 says, upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions that may deem fit, grant stay of the operation of such award for reasons to be recorded in writing. A lot of time, let's say the arbitral award said that Mr. A had to pay rupees 5,000 to Mr. B, supposedly. So let's say Mr. A appeals in the court to challenge the award for the grounds of bias, etc., or for the reasons that are specified in section 34. Now, in that case, what does court generally do? The court will say that you deposit this 5,000 rupees as security. We will put a stay on the enforcement of the award, but you deposit this as a security. If you win this challenge, then the money will be returned to you. So this is a very general procedure that is followed by the court. But again, there is a discretion to the court on how he wants to put a stay on the enforcement of the arbitral award. Court shall, while considering for grant of an arbitral award for payment of money, have due to the provisions for grant of stay of a money decree under the provision of the CPC. So this is what is the provision of CPC, that when they stay on a money decree, the court requests deposit of that amount security. This provision provided in the Civil Procedure Code. Provided further that the court is satisfied a prima facie case is made out that the arbitration or agreement or contract, which is the basis of the award. So here we are talking about a situation where the court is satisfied there is a prima facie case. The case is that either the arbitration or contract, which is the basis of the award, or the making of the award was induced or affected by fraud or corruption. It shall stay the award unconditionally pending disposal of the challenge under section 34 of the award. So where the situation is that the arbitration agreement is invalid or the award was made by fraud or corruption, in that case, the court can put an unconditional stay on the arbitral award till the challenge is disposed of under section 34. Further, the explanation says, it is hereby clarified that the above proviso shall apply to all court cases arising out of or in relation to arbitral proceedings, irrespective whether the arbitral or closed proceedings were commenced prior to or after the commencement of Arbitration and Conciliation Amendment Act 2015. Right? Is this clear? I'm giving you guys 5 minutes. Please read this section once more so that you do not have any confusion. The slide is open in front of you. Please read it once. Please read it once and let me know if it's clear to all of you. I hope all of you are reading it. Say a yes or no. Let me know what's going on in your head. I'm changing the slide now. I hope all of you have read this first 3 provisions. Is this clear now? Enforcement doesn't mean applicability, Abhilash. Let's say when an award is passed, let's say the award said that party A has to pay some amount of money to party B. Now that award has to be forced, the money also needs to be given. Just passing the award is not enough. Enforcement is the execution of award, nothing else. So when you get, let's say, court, sometimes in the civil dispute, you will see court attachment award of attachment of its own. There is a machinery that is required to take place to execute that award. There will be involvement of police, right? There will be involvement of staff. The sealings will be done. So this is enforcement. The award, the execution of the award is called the enforcement. Is that clear, Abhilash? Is this section clear to all of you? Any confusion in this? You need more time for reading. If you need it, do let me know. See, it's such a basic chapter. I really want that after going from the class, you don't end up investing too much time on this. So I just want to prepare you guys so well that everything just stays in your brain and you don't have to keep on revising it. Once you read it, you are through with it. So it's good to invest time here itself rather than invest it again and again and again and again. Is this section clear? Money decree means an award which involves payment of money. So like when you go for a recovery suit and the court awards says that you have to pay this amount with this amount of interest, such a order from the court is called a money decree. So if the arbitration award is such that it involves that there has to be some payment of money, in that case, when the court grants a stay on the enforcement of an award, in that case, it will follow the procedure. So let's say the award said that Mr. A has to pay 10,000 crore rupees to Mr. B along with an interest of 18% per annum, supposedly. Now the court, when it is putting a stay on this arbitral award, when he's putting a stay on this arbitral award, in that case, the court will request Mr. A that you deposit this much amount of money with the court as a security, right? So the money is not given to Mr. B also. It's not with Mr. A also. It remains with the court as a security. So such kind of awards which involves money transactions are called money decree. So arbitral tribunal passes an award. Arbitral tribunal does not pass a money decree. The final decision of the tribunal is called the arbitral award. It's not called the decree. Decree is passed by the court, but it is treated equivalent. Are you clear on that? So the procedure that is followed, the procedure that is laid down in the civil procedure code, the same procedure has to be followed. The procedure that has been laid for the money decree. Money decree is an order for payment of money. Is this clear? Jay, is your question clear? Yes, Abhilash, this chapter is extremely scoring. You don't get a lot of technical, confusing questions here. These are very simple questions. Free ke 3 marks. Is the question clear, Jay? Please say a yes. Guys, are we good to proceed further? Now, talking about the types of arbitral award. So there are 4 types. One is the final award. Now, what do you understand by the word final award? Can somebody answer me? What do you understand when you hear the word final award? Please answer. Put your answers in the chat box. This is why we have the provision for chat box here. Final award is the award that is passed after adjudicating all the disputes that has been submitted for arbitration. So it is the full conclusion to the disputes that have been submitted for arbitration to the arbitral tribunal, correct? Second award that we talk about is the interim award. Now, the interim award is an award that is passed in between. So the arbitration proceedings are still ongoing, but still an award is passed in between. Now, this interim award can be of 2 types. Now, let's take a situation. There were 4 disputes between the parties, correct? 4 disputes. Now, out of these 4 disputes, the 2 have been adjudicated, and the tribunal passes an award, an interim award regarding these 2 disputes, and the award that has been passed regarding 2 disputes is final in nature. So later on, when the final award comes in future, this award pertaining to this 2 dispute will stay constant. Another situation is an award which is in existence only till the final award is passed. So it is a temporary award which remains in force, or which is to be considered only till the final award is made. So that is called the interim award. The third situation is a settlement award. What do you understand when you hear the word settlement? What do you understand with the word settlement? Please tell me, what do you understand when you hear the word settlement? Please tell me. Today I have only 2 interactive students. One is Abhilash and one is Jay. What has happened to Sumit today? In the previous class, Sumit was very active. Agreement? No. Settlement happens when the parties, even though the matter is for adjudication in the court, in front of the arbitral tribunal, the parties amongst themselves settle their dispute. They come to a settlement. So let's say there is a recovery suit, or there is a check bounce case pending in the court of law, correct? So party A has filed a suit for check bounce against party B, and it is pending in front of the Metropolitan Magistrate, correct? Now, party A and B, out of the court, they decide, say, party A wants to recover rupees 100 from party B. Party B says, I don't have 100, you take 95 rupees and let's close it. And party B gives 95 rupees to party A. So what will happen? Party A will go to the court and will say that we have settled the matter out of the court and we do not require court's intervention. So this is a settlement. So the terms of the settlement, when they are recorded in the award, they are called a settlement award. Correct? The 4th type of award is the additional award. So additional award happens, supposedly the final award was made. Later on, the parties realized that one of the disputes that was made to the tribunal has not been resolved. So the party says that this dispute was left behind. So in that case, the tribunal passes an additional award pertaining to the dispute that was left to be adjudicated upon. So let's go through this. Final award is an award that is made in accordance with the requirements of the law and finally adjudicates on the issues submitted to arbitration. Second is interim award. So interim awards can be 2 types. One which remains in force till the final award is rendered, and the other is final as regards the matter it deals with. So the latter is referred to as interim because it was rendered when there was issues that were still pending. The settlement award, if during arbitral proceedings the parties settle the dispute, the arbitral tribunal shall terminate the proceedings, and if requested by the parties and not objected to by the tribunal, record the settlement in the form of an award on agreed terms. So this is referred to as a settlement award. Additional award, when a final award has been rendered, but it is later found out that certain claims that had been submitted to the arbitral tribunal were not resolved or adjudicated, the parties can request the tribunal to make an additional award covering the issues that has been left out. And such a request has to be made within 30 days from the date of receipt of the final award. And if the tribunal considers the request, it shall make the additional award within 60 days from the date of the receipt of such request. And the tribunal may extend the period if necessary for the period of time within which it can make an additional arbitral award. Now, these points that I have marked in green, this is only for your knowledge purpose. It is not provided for in the syllabus, but I mentioned it so that you have a complete understanding of it. Interim award, is it clear? Abhilash, interim award is clear now? Please read interim award from here once. All those of you are having a confusion, please read about interim award from here once and let me know if that confusion is resolved after reading. Is it clear now, Abhilash? Okay, I'm assuming that this is clear now. I'm not receiving any responses. Now let's quickly take this example. So Nagpur Metro Rail Corporation entered into a long-term concession agreement with Nagpur Airport Metro Express Private Limited, a subsidiary of Reliance Infrastructure, to develop and operate the Airport Express Metro project, which included bringing in rolling stock. Namapel was to run the metro service for 30 years. This agreement was entered into 2008 and terminated in 2012. The main disagreement was failure to fix civil structure defect, misrepresentation to viability of project, failure to transfer outstanding amount, and failure to acquire land, hampering developments of other lines. Now, all these, according to Namapel, led to delays in turn, contributing to cost escalation. Now, the matter was submitted to a three-member tribunal for adjudication. Now, the first scenario is tribunal gives an award dealing with the all four disagreements. So what it will become? It will be a final award because it is the conclusive award. Scenario 2, tribunal renders an award which deals only with disagreements A, B, and C. The arbitrator informed the parties that they will render another award dealing with D. So award number 1 here becomes the interim award. But this is the kind of interim award where regarding A, B, C, it might be final. Correct? The third scenario is the tribunal gave an award and informed the parties that this was the final award. However, when the parties examined, they realized that the award only dealt with dispute A, C, and D, and B was left behind. So when the tribunal will adjudicate the B dispute, this will give an additional award. And scenario 4 is, while the arbitration proceedings were going on, the lawyers of both parties met for discussion. They informed the tribunal that the parties had settled the matter on disagreements, and they submitted the settlement agreement to the tribunal with the request that it be incorporated into the award. So the tribunal, after scrutinizing the agreement, gave an award in which they included the terms of agreement. So this becomes a settlement award. Is this clear? No, J, check bounce cases can't be arbitrated. It's a criminal offense. Only court can adjudicate upon check bounce cases. Guys, is this clear? Now, what are the necessary requirements of an arbitral award? First requirement is that the decision has to be made by the majority. Second thing is the writing, signed and dated. Now, when we talk about writing, signed and dated, the arbitral award always has to be in writing and has to be signed by the members of the arbitral tribunal. Let's say the tribunal comprises of 3 members. 2 members are in favor of the award and 1 is against. So is it necessary that all 3 have to sign? No, only the majority members need to sign the arbitral award. The court requires the majority signing. All can sign as well, but it is not a mandate that all the members of the tribunal have to sign, right? So if you look at this section 31 says, an arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. For the purpose of subsection 1, in arbitral proceedings with more than one arbitrator, the signature of the majority of all the members of the tribunal shall be sufficient, so long as the reason for any omitted signature is stated. So majority can sign, but the reason for the omitted signature has to be stated. Third requirement is the award has to be reasoned. It cannot be arbitrary in nature. It has to come from valid grounds. So 31(3) says, arbitral award shall state the reasons upon which it is based, unless when the parties have agreed that no reasons need to be given. Next, it should not be vague. So if you look at this example here on vagueness, the award notes, the arbitral tribunal finds that Sunil was required to deliver the goods to Anil at the rates which had been fixed in 2015 and not 16. Owing to refusal to provide goods at the agreed rates, Anil was forced to find a different supplier. Anil, as a consequence, suffered losses to the tune of 2 crores. Sunil's action was clearly in violation of the agreement between them. It added the following lines. So, scenario 1, Sunil should compensate Anil. What do you think? It's a clear agreement? Sunil should compensate Anil. So, if it says Sunil should compensate Anil, is it a vague arbitral award or is it a clear arbitral award? Please put your answers in chat box. It is a clear arbitral award or is it a vague one? It is a vague one. Why is it vague? How, when, how much money, in how many installments? Nothing. Scenario 2 is Sunil should pay Anil 2 crores in 2 installments. Is it a clear arbitral award? Please tell me, is it a clear arbitral award? No, even this is not. The third scenario is Sunil should pay Anil 2 crore within 2 weeks from the date of the award, along with 10% interest. Failure to do so will attract additional 2% per day interest on the outstanding amount till the amount is finally paid. Payment should be done through RTGS or through a demand draft. Now, this is a well-drafted, clear, without any confusion, without any vagueness, without any gray areas, a crisp, clear arbitral award. So, an award should be such that it does not leave loopholes for further litigation. The next requirement is date and place of arbitration should be mentioned. The award should be enforceable and capable of being performed. So it should not say anything which is impossible to do or is illegal in nature. So if it is illegal or unenforceable, it will be set aside. Next thing is it should not be illegal. It should not be in violation of public policy. So under the law, a particular award that is in violation of the public policy would be set aside, correct? So any violation of public policy will not be entertained. Next requirement is delivery of the copy of award to the parties. So the copy of the award has to be submitted to the parties. Is that clear? Properly signed, dated copy of the awards is supplied to the parties. So these are the necessary requirements of an arbitral tribunal. Is this clear? Of an arbitral award, I'm sorry. Is it clear, guys? Any confusion on this? Okay, now let's proceed to challenging an arbitral award. What are the situations under which an arbitral award can be challenged? So previously we were talking about challenging the appointment of arbitrator. Now we are talking about challenging an arbitral award. What are the grounds under which an arbitral award can be challenged? So first is there is a challenge of bias against the arbitral tribunal. This is something we already know. So parties can challenge the appointment of tribunal for biasness. Second situation was overstepping of jurisdiction by the tribunal. So let's say tribunal has the power only to adjudicate upon certain disputes. So if it adjudicates upon the disputes which is outside its jurisdiction, in that case, it can be challenged, correct? Now we talk about section 34, the most important section which talks about grounds for setting aside the arbitral award. So section 34 provides for specific grounds for review of an award. So section 34 says an arbitral award may be set aside by the court only if the party making the application furnishes a proof that the party was under some incapacity, the arbitration agreement is not valid under law to which the parties have subjected it, or failing an indication thereof under the law for the time being in force. The party making the application was not given a proper notice of the appointment of an arbitrator or of the proceeding, or was unable to present his case. So here we are talking about situations where arbitral award may be set aside. What are those situations where the arbitral award can be set aside? Where the party who is making an appeal, he in the application furnishes the proof. Proof of what? One, either the party was under some incapacity. Second, the arbitration is not, agreement is not valid under the law. Third, the party to the application was not given the proper notice of appointment of arbitrator or arbitral proceedings, or was unable to present his case. Correct? Fourth, the award deals with a dispute not contemplated by or not falling within the terms of submission to arbitrator. That means the matter is not arbitrable. It is outside the scope of the arbitration agreement. Correct? So let's say we say only disputes pertaining to the payment of invoices will be submitted to arbitration, correct? Now, supposedly there was a dispute pertaining to the delay in the delivery of services, and that matter was submitted to arbitration and has been adjudicated also. Can it be set aside in front of by the court? Yes. So here appeal will lie under section 34 because the dispute was not to be was beyond the jurisdiction of under the arbitration agreement, right? Next situation is where the composition of the tribunal or the arbitration procedure was not followed in accordance with the agreement of the parties. Correct? So these are the 5 situations under which the party can make an application to the court for setting aside an arbitral award. So when it is making an application for setting aside an arbitral award, it will also have to submit a proof that he was under some incapacity, the arbitration agreement is not valid under law, party who is making the application was not given proper notice, the appointment of tribunal or the arbitration proceedings was not in accordance with the agreement, or the dispute that has been adjudicated is beyond the scope of the arbitration agreement. So these are the 5 grounds on which the party can make an application to the court. However, there are some situations where the court can suo moto on its own set aside an arbitral award. So those situations are where the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force. That is, it is a non-arbitrable matter. So let's say the dispute is regarding theft, right? Or the dispute relates to some criminal offense like financial misrepresentation or cheating, forgery of signatures. Such disputes cannot be arbitrated. And second is the arbitral award is in conflict with the public policy of India. So where the arbitral award is in public policy conflict with public policy, the court may suo moto set aside the award. So in the explanation, the law says it is clarified that an award is in conflict with the public policy of India only if the making of the award was induced or affected by fraud or corruption, or was in violation of section 75 or 81. It is in contravention in the fundamental policy of Indian law. It is in conflict with the basic notions of morality or justice. You don't have to get into so much of detail on what is section 75, what is 81, morality, justice. All you have to know that if the arbitral award is in conflict with the public policy of India, it will be set aside by the court. Further, section 2A says the arbitral award arising out of arbitrations other than international arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. That means the award on the face of it appears to be incorrect. मतलब अगर आपको दिख रहा है कि जो मैटर और जो डिस्प्यूट्स रखे गए हैं सामने दिखते ही समझ आ रहा है कि अवार्ड गलत पास किया गया, झूठा है, गलत तरीके से बनाया गया है, then also it can be set aside. However, it is provided, so there is a proviso that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. So merely because there was a erroneous application of law, it cannot be set aside, but where there is a patent illegality on the face of the award, only then it can be set aside. Is that clear? Is this clear, guys? Grounds for setting aside an arbitral award? Guys, is this clear? Please say yes or no. The grounds for setting an arbitral award, setting aside an arbitral award, is it clear to all of you? So what are the different grounds that we saw for challenging an arbitral award? First was under section 13, where there is a challenge of bias against the arbitral tribunal. Second was under section 16, where there was overstepping of jurisdiction by the arbitral tribunal. So in where we were talking about section 13 and 16, in this case, first challenge lies with the tribunal itself. And if the tribunal does not make a corrective action, then we go to then the arbitral award is challenged, given by a challenge in the court. Then there was section 34, which provides for specific grounds for reviewing an award. So when we talk about specific grounds of reviewing an award, there are 5 grounds under which party can make an application, and there are 2 grounds where the court itself can nullify the award or can review the award. What are the 5 situations where the party can raise the application? One is contractual or personal incapacity of the parties, invalid arbitration agreement, party is not given proper notice of appointment of arbitrator or arbitral proceeding,
award deals with dispute that is not submitted for arbitration, or the procedure tribunal or the procedure was not in accordance with the arbitration agreement. So these are the 5 grounds. What are the situations where court can raise itself the review of arbitral award? 1, the matter of the dispute is not capable of settlement by arbitration. And second, the award is in contravention of the public policy of India. So these are 7 grounds where the arbitral award can be challenged or reviewed by the court. And these are the specific grounds that can be raised by the party for challenging an arbitral award. Is that clear? Is this clear, guys? I have re-explained. Overstepping of jurisdiction means, just the way I told you, when we define the arbitration agreement, when the arbitration clauses are drafted, there are specific areas or disputes that can be adjudicated through arbitration. There are situations where only a specific dispute can be adjudicated through arbitration. So if there was a dispute which is not a right within the arbitration agreement, then it cannot be. This is called overstepping of jurisdiction. So let's say dispute only pertaining to money can be resolved through arbitration, but the parties referred a dispute pertaining to the delay in the progress of project. In that case, this is overstepping of jurisdiction. Is that clear? Now, is it clear to all of you? Please say yes or no. This is an important section. Parameter in sense, Abhilash. These are grounds for challenging an arbitral award. You cannot necessarily call them parameters. But always remember that the proof for the same has to be supplied by the party who's making an application for challenging an award. So these are the specific grounds or situations for which an arbitral award can be reviewed. Not for anything and everything you can go on challenging the arbitral awards just because it is adversary to you. Is this clear? Any other confusion? Please let me know, guys. Abhilash, Jay, Sumit, is this clear? Are we good to proceed further? So I have noted this here. Now, how does an application for setting aside an arbitral award is to be made? So the application for setting aside an arbitral award can be made by any party to the court. So it is only the party to the arbitration proceedings who can make an application for setting aside an arbitral award. Second thing is, such application will have to be made within 3 months from the date such party had received an award. Now, if the court is satisfied that the applicant was prevented by sufficient cause from making this application within 3 months, it may entertain the application within a period of further 30 days, but not thereafter. So it is a strict provision. Such application is to be made by party only after issuing a prior notice to the other party. Now the question arises, this requirement of issuing a prior notice to the other party, is it mandatory in nature or is it merely directory? What do you think? Is it mandatory to issue notice, prior notice to other party while making an application for review of arbitral award? No, it is just directory in nature. This we will see. I'll mention some case laws under which it has been specified by court that it is not mandatory, it is only directory in nature. On receipt of an application, under the court may, where it is appropriate and is so requested by party, adjourn the proceedings for a period of time determined by it in order to give the tribunal an opportunity to resume the proceedings or take such other action as in the opinion of tribunal will eliminate the grounds for setting aside the arbitral award. So let's say there is a scope where arbitral award can fix the problem pertaining to the passing of the arbitral award, then it is given an opportunity. And this application for setting aside an arbitral award has to be dealt expeditiously by the court, and it has to be decided within a period of 1 year from the date on which the notice referred is served upon the other party. So there are few case laws which I have mentioned here. So in the case of Anil Kumar Jinabhai Patel versus Praveen Chandra Jinabhai Patel, it was said that the limitation period that has been prescribed under 34(3). Now the limitation period is 3 months, which is extendable by 30 days, would commence only from the date of signed copy of the award delivered to the party making application for setting aside. So let's say the award was passed on 10th February 2022. The signed copy of the award was delivered to party B on 18th February 2022. So this limitation of 3 months that we are counting, we will be counting from 18th February 2022 and not 10th February. This is what is meant here. So the court said that the limitation period will commence from the date of signed copy of the award delivered to the party making the application for setting aside. So if it is party A who is making the application, it was delivered to him on 18th Feb, 3 months would be counted from there. If the award is being setting aside, application for setting aside, the award is made by party B and the party B received the award on 16th Feb, so 3 months would be counted from 16th Feb. This is how it functions. Is this clear? Any confusion on this part, on the limitation period for making an application for setting aside an arbitral award? Now, the same thing that I was talking about, whether prior notice of an application under 34 is directory or mandatory. So in this case of State of Bihar versus Bihar Rajya Bhumi Vikas Bank Samiti, contrasting section 34(5) with section 80 of the CPC, Supreme Court observed that to construe such a provision as being mandatory would defeat the advancement of justice. Therefore, prior notice to the other party before filing application to set aside arbitral award is not mandatory and merely directory in nature. The next question arises, whether a clause in an agreement excluding interest on security deposit can act as a bar on the arbitrator to award pendente light interest. So the court in this case of Ravachi versus Union of India, they relied on a 3-judge bench decision of Union of India versus America Construction and held that an arbitrator has the power to award interest unless specifically barred from awarding it. It was clarified that the bar must be clear and specific. It was further held that the bar to award interest on the amounts payable under the contract would not be sufficient to deny the payment of interest pendente light. So there has to be a specific bar on awarding an interest. Till then, arbitrator is free to award interest on the amount that is payable. Correct? Is this clear? So what are the points that we discussed here? How an application for setting aside arbitral award has to be made. Any party to the arbitration proceeding can make an application for setting aside an arbitral award. To whom the application will be made? Application will be made to the court. Which court? If it is a domestic arbitration, it will be made to the district court or the high court, depending on the original jurisdiction. If it is an international arbitration, it will be made only to the high court. What is the timeline or the limitation period within which the application is to be made? It is 3 months. 3 months from where? 3 months from the date of receipt of the signed copy of the award by the party who is making an appeal against the arbitral award. So let's say the arbitral award was given to party A and B. Party A received the signed copy of the arbitral award on 14th Feb. Party B received the signed copy of the arbitral award on 18th Feb. So if the party A wants to challenge the arbitral award, he can challenge the award within 3 months. That is March, April, May. Within 14th May, it can challenge the arbitral award. If it is party B who wants to challenge the award, it can file the application up to 18th May because it received the award on 18th February. So this 3 months that we count, it is to be counted from the date of receiving the signed copy of the award. The second requirement is that an intimation or notice has to be issued to the other party before making an appeal against the award or before making an application for setting aside the arbitral award. Now the question arises, is the requirement of notice mandatory in nature? The answer is no, it is directly in nature, which has already been decided by Supreme Court. Is this clear? Is it clear now, Jay? The concept of 3 months? Jay, is this clear? Please say yes or no. Is this clear? So, what are the consequences of challenging an arbitral award? 4 consequences: set aside, confirm, modify, remit back to the arbitral tribunal, which I have already discussed with you. I had already told this to you, whether a person who is not a party to the arbitration agreement can file a petition for challenging arbitral award under 34? No. In the case of Mukesh Nanji Gala versus Heritage Enterprises, court held that the third party who is not a party to the arbitration agreement cannot be allowed to implead as a party to arbitral proceedings. Correct? However, if a person is wrongly impleaded as a party to the proceedings and is aggrieved by the award, then he can invoke section 34. Next is enforcement of arbitral award, that we have already discussed, that it is enforced as a decree of the civil court under the Code of Civil Procedure 1908. So this is all about arbitration. Okay, are we good till here? Any conclusions here in arbitration part? We can take 5 minutes. What we can do is before starting conciliation, we can take a 10 minutes break. You will have 10 minutes to go through the arbitration part. And then when we meet again after 10 minutes, we can first discuss the queries of the arbitration and then start with conciliation. The difference between arbitration and conciliation also I will take up once I finish conciliation for you. And then we will take up the difference between arbitration and conciliation. Is this clear? So we can take a quick 10 minutes break here and I will meet both of you in another 10 minutes. Okay? Okay, welcome back all of you. Are we good to start again? Any confusions regarding arbitration, any of the part of arbitration that we have already discussed? Please let me know if there are any queries and any confusion pertaining to arbitration part. I was expecting a lot of queries from students in 10 minutes. Everything is clear to everybody? Okay. Now proceeding to the conciliation. So arbitration was one of the mechanisms of alternate dispute resolution that has been provided for in the Arbitration and Conciliation Act 1996. Now, other method of alternative dispute resolution that has been provided for is conciliation. Now, when you talk about arbitration, it is very much like a court system. It is not a court system, but it is similar in terms, yes, you have the freedom to choose the arbitrator with appropriate technical knowledge that you need or proper expertise that you would need for adjudication of dispute pertaining to your matter. You can decide upon the seat of arbitration, the law you want to be subjected to, the number of arbitrators you want, the kind of disputes that you want to be arbitrated, how you would appoint an arbitrator, who would be an arbitrator, or maybe you can ask somebody else to appoint an arbitrator on your behalf. So yes, a lot of autonomy, flexibility is there. But once the arbitral tribunal is constituted, the proceedings, if you see, are very much similar. One party will submit his complaint, the other party will submit a written statement to it. Both the parties will give their evidences, then the evidences will be examined, the witnesses will be examined, the statement will be recorded, the cross-examination will be done. All of these things are to be done, which is very much like court procedures. Yes, it is time bound. There is specific time that has been provided for that the entire proceedings has to be completed within a period of a year. But both the parties are still fighting here for their own rights. And there is a possibility that there can be development of some bitterness between them, which can destroy their relationships. Now, in order to avoid these consequences of arbitration, conciliation method of ADR can be adopted. A lot of times you will see the arbitration or the dispute resolution clause that we get to see in agreements, like one of the dispute resolution clause that we had discussed in our previous class. The first step of dispute resolution it mentioned was amicable resolution of disputes with the intervention of senior management team and the shareholders of the company. The other provided for the next step was conciliation, and then it provided for arbitration. So usually the dispute resolution mechanism that you generally see that are being adopted by a company, it's a tier-wise mechanism. They always split it. So arbitration is a good choice that the parties have, but we cannot necessarily say that it is a cheap method of dispute resolution. The fees of arbitrators are really hefty these days. Plus, you need intervention of lawyers with all that management of submission of legal documentation, written statements, etc. So it very much mimics a court procedure. Even though you do not directly go to the court where thousands of people are sitting, there is confidentiality, you are in a closed room, all these things are there. But there is always a provision to or there can be situations where the matters can be resolved by a minor intervention by a third party who can help the parties to resolve their own disputes. Is that clear? So this is what is conciliation is all about. Okay. So before I proceed further on conciliation, Abhilash, you have some questions. Please tell me. Jay, the difference between mediation and arbitration and conciliation, both of it I'll take up in the upcoming slides. Don't worry about that. Abhilash, what are your questions pertaining to arbitration? Please put your questions in the chat box.
so that I'm able to answer it before I proceed for conciliation? I haven't received any questions from you yet. Please share your questions, Abhilash. I'm waiting for you to share your questions. Okay, I think there is some time gap between students sharing their questions and me receiving it. So what we can do, whatever questions or queries that keep coming to your mind, you can continue putting that in your chat boxes. After I finish conciliation, I'll take up the queries one by one. So whatever queries you have, you keep on putting it in the chat box. Okay, once I complete teaching the conciliation part to all of you, I will take up all the queries one by one. Okay, I hope that's not a problem. Now, coming back to conciliation. So if you talk about the definition of conciliation, there's none that has been specifically provided for as a clear-cut definition. But if you talk about procedures, the guidelines that has been provided for in Arbitration and Conciliation Act 1996. Conciliation also finds a mention in the section 89 of the Civil Procedure Code. Now, when you look at conciliation and how it differs from arbitration, if you see, arbitration is very much a legal process, but conciliation has no legal standing. In case of arbitration, the arbitrator can summon witnesses, he can seek evidence. So the arbitrator is equivalent to a judge, but a conciliator is not. Conciliator cannot seek evidence, he cannot call witnesses, he does not write a decision, or he does not make an award. He only gives recommendations and suggestions and help the parties to resolve their disputes amicably. So basically, he's a third person, neutral third person, who is helping the parties to resolve their disputes. He is not the one necessarily who is adjudicating upon the dispute. So arbitrator judges the dispute. He takes information from both the parties and decides upon the matter. And then he passes his judgment. Whether guilty, not guilty, need to pay, need not need to pay, whatever. But conciliation is not such a scenario. In conciliation, there is a neutral third party who is helping both the parties to resolve their matter and come down to a situation where they can amicably resolve their dispute. So neither he is passing any arbitral award which is final and binding upon the parties, nor it can call witnesses, nor it can demand some particular information to be provided. So it is basically the parties who are resolving their dispute with the intervention and help of a neutral third party who is playing an active role and helping the two parties who are under dispute to resolve the dispute amongst them. So now talking about the characteristics of conciliation, one of the characteristics is that it is voluntary in nature. So both the parties have to voluntarily be willing to resolve their disputes through conciliation. If one of the party is forced for conciliation, the decision that is decided, it will not be binding on the party. So parties' autonomy and consent are crucial here also. Second is, it is non-adversarial in nature, because here both the parties are not competing against each other to get a decision in their favor. Here the parties, instead of focusing on the win and the lose, they try to find a solution to the problem that suits to both the parties, a midway that is in favor of both. There is no way that we have to come at a conclusion which is favorable to one and adversary to another. So here a midway is to be found. Third thing is that it is a assisted procedure. So who is the person who is assisting this solution driven approach? It is the conciliator who is assisting and actively participating and recommending solutions for the resolution of dispute between the party and to help the parties to reach a amicable settlement. Fourth is the finality of the outcome.
So whatever settlement the parties reach at the end of conciliation process, it is final and binding upon the parties. Next important feature is confidentiality. So just like arbitration, even conciliation process is confidential in nature. The parties are not permitted to disclose any information pertaining to conciliation to any other party. However, within the process, information that is received by the conciliator from one party must be disclosed to the other party, right? So there is a broad spectrum of confidentiality operating in the conciliation process as well. So whatever information that is shared, it remains confidential within the parties. So summing up the key characteristics of conciliation: one, it is voluntary, non-adversarial, assisted, finality of settlement, and confidentiality. So these are the 5 key characteristics of the process of conciliation. Okay. Now, as we talk about the legal framework, we know that Arbitration and Conciliation Act, along with Section 89 of the CPC, deals with the legal framework of conciliation. Now, the question arises, what kind of disputes can be resolved through conciliation? It is only the disputes that are arising out of legal relationships. Anything which is pertaining to illegal, which is illegal in nature, that cannot be resolved through conciliation. Now, let us look at Section 61 of Arbitration and Conciliation Act. It says, save as otherwise provided by any law for the time being in force, and unless the parties have agreed, this part shall apply to conciliation of disputes arising out of legal relationship, whether contractual or not, and to all proceedings relating thereto. So this talks about the applicability of Part 3 of the Indian Arbitration Act. So it will be applicable to conciliation of disputes that is arising out of legal relationships, whether contractual or not. This part shall not apply where by virtue of any law for the time being in force, certain disputes may not be submitted to conciliation. So it is only the disputes that can be conciliated to them this part will be applicable, not to every dispute. So there is a limitation on what kind of disputes can be resolved through conciliation. Correct? Now, talking about the commencement of conciliation proceedings. How does the conciliation proceedings begin? That is provided for in Section 62 of the Act. So subsection 1 says, the party initiating conciliation shall send to the other party a written invitation to conciliate under this part, briefly identifying the subject of the dispute. So what is happening here? Let's say there is a dispute between party A and party B, and there is a dispute. So party A wants to conciliate the matter. He will send a written invite that this is the dispute between us and we are willing to resolve it through conciliation. Now, what is expected out of party B? Party B, just 1 minute. Party B is expected to give his consent. Either he will accept the invite or he will reject it. So the conciliation proceedings will commence only when the other party accepts in writing the invitation to conciliate. Now, one of the situation arises here. What if the other party does not respond altogether? Neither it says yes, nor it says no. There is no response. Then what will it be considered? It will be considered as if the consent has not been given or the other party is rejecting the invitation. So if the other party rejects the invitation, there will be no conciliation proceedings. Now, if the party initiating conciliation does not receive a reply within 30 days from the date on which he sends the invitation, or within such other period of time as specified in the invitation. So if he doesn't receive a reply within 30 days from the date he sends the invite. So maybe he sends the invite on 10th Feb, but the other party receives it on 12th Feb. So the 30 days from the date of sending the invitation, or the time period that has been specified. So the invitation might specify that we are looking forward to your acceptance to it within 15 days from the date of receipt or from the date of this invite, right? So these customizations are possible. So if the party initiating conciliation does not receive a reply within 30 days from the date on which he sends the invitation, or within such other period of time as specified in the invitation, he may elect to treat this as a rejection of the invitation to conciliate, and if he so elects, he shall inform in writing the other party accordingly. So this is how a conciliation proceeding is started. The party who wants to conciliate sends a written invitation along with the briefly informing about the subject matter of the dispute. The other party will have to reply its acceptance in writing. If he rejects, there will be no conciliation proceedings. If the party who initiates the conciliation proceeding doesn't receive a reply within 30 days of sending notice, he may elect to give up on the conciliation proceedings. Now, talking about the process of conduct of conciliation proceedings, how the conciliation proceedings are conducted. So the first requirement here is the number of conciliators. So there can be 1 to 3 conciliators. That is the maximum of number of conciliators that can be appointed is 3. Generally it is 1, but it can be up to 3. In arbitration, there can be 5 arbitrators also, there can be 7 arbitrators also. But in conciliation, there is a limit on 3. So if you read section 63, it says, there shall be 1 conciliator unless the parties agree that there shall be 2 or 3 conciliators. So it is subject to the agreement between the parties. But generally, you get to see 1 conciliator. Where there is more than 1 conciliator, they ought, as a general rule, to act jointly. So when there are more than 1 conciliators, they have to act jointly, that is together. Now, talking about appointment of conciliators. So appointment of conciliators is subject to the consent of parties. So the conciliators are appointed by the parties, or the parties can request an institution for appointment of a conciliator. Like they can appoint in Indian Center for Alternate Dispute Resolution requesting for an independent and impartial conciliator. So section 64 reads that, subject to subsection 2, in conciliation proceedings with 1 conciliator, the parties may agree on the name of a sole conciliator. So what's happening? The 2 parties can mutually decide upon the name of conciliator. Where there are 2 conciliators, each party can appoint 1 conciliator each. And where there are 3 conciliators, each party can appoint 1 conciliator, and they can agree mutually on the name of the 3rd conciliator. So here, the appointment of the 3rd conciliator is done mutually by the parties. It is not the conciliator who is appointing the 3rd conciliator. So in arbitration, what used to happen, where there were 3 arbitrators, both the parties appoint 1 arbitrator each, and the 2 arbitrators who have been appointed, they mutually appoint the 3rd arbitrator. But in conciliation, it's not the case. If there are 3 conciliators, both the parties appoint 1 arbitrator each, and they mutually appoint a 3rd arbitrator. They mutually agree. The parties mutually agree on the name of the 3rd conciliator who acts as the preceding conciliator. So if you read subsection clause C, it says, in conciliation proceedings with 3 conciliators, each party may appoint 1 conciliator, and the parties may agree on the name of the 3rd conciliator who shall act as the presiding conciliator. Now subsection 2 says, parties may enlist the assistance of a suitable institution or person in connection with the appointment of conciliator. And in particular, a party may request such an institution or person to recommend the names of suitable individual to act as conciliator, or the parties may agree that the appointment of one or more conciliator may be made directly by such institution. So what is happening? There is a provision which permits taking support from institution. So either the parties can decide that they can request an institution to recommend the name of suitable conciliator, or then they can request the institution itself to directly appoint a conciliator. So whatever is being decided, it is by the consent and free will of the parties who are willing to adjudicate their disputes through conciliation. So whenever an institution is appointing a conciliator, or he's recommending the name of the conciliator, he will ensure that such a conciliator who is being appointed is independent and impartial, right? So that is an important characteristics that have to be taken in mind. Now, what happens that once the conciliators have been appointed, so firstly, there is an invitation for conciliation. Second step is the appointment of conciliators. Now, once the conciliators has been appointed, he will request both the parties to submit their statement in writing, supply documents and other evidences to the conciliator. Then conciliator will exchange the statements. Like if party is providing some statement, that will be served, a copy of it will be given to party B. If party B is also supplying some documents and evidences, a copy of it will be supplied to the party A. And then the conciliator will encourage. So what is happening? There is a complete disclosure of information or point of views of both the parties. And then conciliator encourages and helps and assists the parties to engage in a discussion to come down or to identify a solution or to arrive at a settlement for the resolution of their disputes. Is that clear? So basically this giving of information to the conciliator is only to ensure that there is a complete exchange or disclosure of information between both the parties who are having some dispute. And then the conciliator takes active participation and helps them to arrive at a settlement. Now, Section 77 of the Act says that when the conciliation proceedings are ongoing, the courts cannot approach the parties to the dispute cannot approach the court regarding the same dispute which is part of conciliation proceedings. But there is an exception that has been carved out for this. What is this exception? The exception is when there is a requirement for preserving the right of one of the parties, they can approach the court or initiate arbitration. Now, what are these rights that we are talking about that you'll be able to understand when you go through this example? So let us have a look at this example. So in this example, Prakash and Rumi are business partners. Their partnership firm, Fruit and Flowers, are dealers in fresh fruits and exotic flowers. Their clientele include various high-end hotels, marriage venues, and other institutions in and around Delhi. They have standing orders from many for daily supply of flowers, both exotic and otherwise. One of their regular clients is Orion Decorators in Gurgaon, which specializes in flower decoration. Over the year, it has built a name for itself in the business of flower decoration at marriage venues. Now, Fruits and Flowers and Orion Decorators have had business dealings for many years. Now, in 2016, Fruits and Flowers was sold by Prakash and Rumi to Sanjay. Now, this Mr. Sanjay, the first thing that he did after taking over was to drastically increase price for exotic flowers. So obviously when he took over Fruits and Flowers, there were existing Client relationships, there were existing orders. There were people who had given pre-hand given orders for the upcoming weddings or for venues, etc. Now, one of the client that was most hit was Orion Decorators, because they had already taken several orders based on previous pricings of fruits and flowers. Now, the increased pricing meant that the Orion Decorators would incur substantial loss, being the peak of marriage season. Orion Decorators requested fruits and flowers to honor their long-standing business relationship and provide flowers at earlier price. Sanjay refused outright, but agreed to have the matter conciliated. So the matter is to be conciliated, but conciliation will obviously take some time. Now, in the conciliation proceedings, which started the next day, Sanjay refused to provide flowers unless the higher rate was paid. So what's happening? Sanjay is saying, till you pay me higher price, I'm not giving you flowers. If Orion Decorators does not get the flowers, he will suffer tremendous loss because he had already made commitment for others. So he can reach out to the court to continue to receive exotic flowers that is required by him. So in this case, this is an exception where he can approach the court to protect his right. So here Orion Decorators could approach the court for interim measures where till the conclusion of conciliation proceedings, it could request the court to direct Sanjay to continue providing flowers at the lower rates. And court have the power to pass orders whichever it deems appropriate. So here he is reaching out to the court for protection of his right or for interim support or an interim relief. So basically he can reach out to the court for interim relief where his rights are being hampered or to protect his rights. So this is the exception that has been carved out in section 77 of the Act. Is that clear? Now, talking about termination of conciliation proceedings. How can the conciliation proceedings be terminated? One, there is a settlement agreements by the parties. Then on the date of the agreement, it will come to an end. So when the parties resolve the dispute, they come to a settlement. The date on which the settlement agreement is signed, it will come to an end. Second, by a written declaration of the conciliator after conciliation with the parties to the effect that the further efforts at conciliation are no longer justified on the date of declaration. So when the conciliator and the parties have put in enough time and locked heads together and they are not able to reach a settlement, in that case, conciliator can, after consultation with the parties, give a declaration that there is no point investing more time. Third is by a written declaration of the parties addressed to the conciliator to the effect that the conciliation proceedings are terminated on the date of declaration. Fourth, by written declaration of a party to the other party and the conciliator to the effect that conciliation proceedings are terminated. So there are four situations. One is parties reach a settlement, then on the date on which they sign the agreement, the conciliation proceedings will get terminated. Second is conciliator gives a declaration that enough time has been invested, the parties have been consulted, and there's no point investing more time. So the date on which he gives the declaration to the parties, the conciliation proceedings will terminate it. Third situation is the parties together make a declaration to the conciliator that they want to terminate the conciliation proceedings. In that case, on the date of the declaration, the conciliation proceedings will terminate. Fourth is where one of the party makes a declaration to the other party and the conciliator for the termination of conciliation proceedings. Then also on the date of the declaration, the conciliation proceedings will get terminated. So this is all about conciliation in India. This is all that you need to know. When you talk about definition of conciliation, law does not provide a specific definition. All you can understand is having a neutral third party to assist the parties in coming down to a settlement of dispute. Correct? Now, what is the difference between conciliation and mediation? In case of mediation, the mediator only plays a facilitative role. He just facilitates the resolution between the parties. But in case of conciliation, he plays a proactive role. He can also suggest the solutions. Mediator never suggests the solution. Mediators only makes the both party talks. He creates an environment where both party can talk and come down to a solution, right? In case of mediation, whatever the outcome is, it is an agreement between the parties. But in conciliation, there is a settlement agreement that is drafted by the conciliator and signed. In mediation, the agreement that is reached by the parties is a contract which is enforceable by the law. And in case of conciliation, the settlement agreement which is reached between the parties has the same status as an arbitral award on the agreed terms. Mediation is governed by Section 89 of CPC, conciliation by Part 3 of Arbitration Act. Mediation is governed by confidentiality, but that confidentiality is based on trust. But for conciliation, it is one of the key characteristics. So breaking of confidentiality can be fatal. If the mediation agreement is breached, the provisions of Indian Contract Act regarding breach of contract will come into picture. But where the settlement agreement is enforced as an arbitral award, so breach of the settlement agreement would be equivalent to the breach of an arbitral award. And the Arbitration and Conciliation Act provides mechanism for enforcing arbitral award and recourses in the instances where the award is not followed. So there was this case where in Supreme Court of India in Salem Advocate Bar Association versus Union of India held that the conciliation is a bigger concept than mediation, and the conciliator plays a much greater role and more involved than a mediator. So you don't have to really focus a lot. Just it's basic, read it, go through it, and it's done. Don't put in too much of brain on this. Settlement agreement, you can say it's not an order. Order is when a party adjudicates upon the dispute as a judge. Settlement is a consensus that is reached between two parties who are in a dispute. Maximum number of conciliators that can be appointed is 3, Abhilash, not more than that. Now coming to the settlement agreement. So the settlement agreement that is reached between the parties in the process of conciliation. So in the initial steps, when you talk about the attempt of conciliation is to resolve the dispute and arrive at a settlement. Now this settlement can be reached on based on the suggestions that is made by the conciliators, or the parties themselves come down to a solution for their dispute. So whenever the conciliator comes to a feeling that the both parties are in a state to resolve their dispute and they are able to find an amicable solution to their dispute, he drafts a settlement agreement in which he includes that solution in a written format. And this settlement agreement is given both the submitted to or handed over to both the parties. If the parties have certain suggestions or observations on that agreement, they recommend that, and accordingly, if the parties are finally agreeable to it, it is signed, right? So this is a situation where parties have not actually reached a settlement, but the conciliator has come to a point where he can feel that there is a possibility that on ABC grounds, a settlement can be achieved. So he proposes that settlement in a way. Second situation is the parties have themselves reached a settlement. They inform their terms to the conciliator, and the conciliator writes down it in the form of an agreement. And this is also known as the memorandum of conciliation, right? So the conciliator will authenticate the agreement, after which it will have a legal sanctity. So it will be signed by the conciliator and the parties. So next is a settlement agreement will have the same status as that an arbitral award, and it is final and binding on the parties who sign the agreement, and the award can be challenged before a court once the time for challenge has lapsed, and if the challenge has not been made, it can be enforced as the CPC. So it is very much similar to an arbitral award. Now, talking about the confidentiality, so conciliation proceedings also require stringent confidentiality. Both the conciliator and the parties have to keep all the matters relating to conciliation and settlement agreement confidential, but they can make a disclosure when it is important for the implementation or enforcement of the settlement agreement. The conciliator cannot act as an arbitrator or representative of any party in arbitral or judicial proceeding. Second, the views that are expressed, the suggestions, the admissions by party, nothing can be used as evidence in arbitral or judicial proceeding. So whatever is said and done and discussed, even if there are some admissions of shortcomings, errors, same cannot be used as evidence if the parties reach out for arbitration or any of the court proceedings. So if there is a breach of confidentiality, it will hamper the entire arbitral or judicial proceedings they are to be utilized in, right? So with this, we finish Arbitration and Conciliation Act 1996. I have brought in a lot of practice questions for you, which we can take up one by one. However, before proceeding on to practice question, I would like to take up queries from students. Whatever queries you can put forward in the chat box. Yes, Abhilash, consent is required. The parties in this, if you see the party who is willing to conciliate the dispute, he makes a invitation to the other party. The other party has a free will to either accept the invitation or reject the invitation. But in case of arbitration, if you see, the arbitration clause comes into picture. If the arbitration agreement says that any dispute pertaining to this contract will be submitted to arbitration, it becomes mandatory to get the matter resolved through arbitration. That becomes the first step. Conciliation is a choice. This is arbitration becomes mandatory. Now, all this depends on how your dispute resolution clause in the contract has been framed. But the procedure that is followed is the same. An invitation is made. If the invitation is accepted, the matter is both the parties exchange information and statement. They come down to a settlement. That settlement is recorded. This is how it proceeds. If they are not able to come down to settlement, they can proceed to the next step, which can either be arbitration or it can be the court proceedings, depending again on how the resolution of dispute clauses has been framed. See, there is no point of appeal in conciliation because there is no adjudication of dispute. There is just settlement of dispute. So let's say when you settle, let's say there is a out of court settlement of a check bounce case. It was for ₹100 and you yourself out of free will agree to pay 95 and the other party agrees to it. What is the appeal there when you have willingly? So there is an appeal of arbitral award because the matter is judged and the arbitral award can be adversary to one of the parties. So there is a requirement for appeal. Conciliation there is no logic of appeal as such. Don't try to mug up things, Abhilash. I request all of our students to just understand things on an applicable perspective. Where do you have a requirement for appeal? Appeal is required only when there can be a situation of adversary, where you have out of your free will consent settled a dispute, have come to a center path where none of you are being affected, both of your rights are being protected, then there is no reason for appeal. But yes, there can be a situation where you are forcefully or on a gunpoint made to sign a settlement agreement. There you can very well reach out to the court or police. But that is not an appeal against the settlement agreement. It is a question of violation of your rights. It is a question of obtaining your consent by threatening and force. So anything Any consent which is obtained by threat or force, it's not a valid consent. That is a separate concept altogether. Is that clear, Abhilash? So yes, arbitration and conciliation appear to be a bit similar, but there are a lot of differences between them. If you see in case of arbitration, there can be 1, 3, 5, 7, any number of arbitrators. But in case of conciliation, there can be maximum 3 conciliators. Process of appointment of conciliator is different from process of appointment of arbitrators. In case of arbitration, there is adjudication of dispute. Thus, there is a right of challenging the award also. In case of conciliation, the parties mutually, amicably resolve their dispute and come to a settlement agreement which is recorded as an agreement by the conciliator. So conciliator is not adjudicating this. He is not judging who is right, who is wrong. Conciliator is just helping the parties कि ओके गलती तुम्हारी कुछ है, कुछ तुम्हारी है, बट कुछ एक मिड पाथ निकालते हैं जिससे दोनों की प्रॉब्लम सॉल्व हो जाए. So there is a difference between resolution of dispute and adjudication of dispute and resolution of conflict. So here one party is not fighting against other party for receiving an order in his favor. Here both the parties are working together to find a middle path and to find a solution to their problem. This is one of the key difference between arbitration and conciliation. Is it clear to all of you? Now let us practice these questions that I have given here. The first question is, which of the following model law was used by Indian Arbitration and Conciliation Act? Please give your answers in chat box. Constitution of India, Guidelines of Supreme Court of India, European Commercial Arbitration Procedure, and UNICTROL 1985. Please answer this question. What is the right answer for this? All of you, we are going to practice questions, so all of you can put your answers in chat box. Yes, the correct answer is D, UNICTROL 1985. Second is, an arbitrator is chosen and paid by the disputant. An arbitrator acts in accordance with privately chosen procedure so far as that is not repugnant to public policy. C, only A is correct. D, both A and B are correct. What is the answer to this one? How is the arbitrator chosen? He is appointed based on the procedure that has been given in the arbitration agreement. If there is no procedure that has been decided upon by the parties, he will be appointed as per the court procedure, as per the procedure that has been provided in the Arbitration and Conciliation Act. So the right answer would be B. The next question is, an arbitral award has to be in writing but need not be signed. Option B, has to be in writing and signed by the members of the arbitral tribunal. C, may be oral. D, either A or B or C. What is the correct answer here? Please attempt this question. You can type your answers in the chat box. Yes, it is correct. It has to be in writing and signed by the members of the arbitral tribunal. Next question. An arbitral award must state the reason upon which it is based. Must state the reason upon which it is based only when the parties have agreed for the same. Need not state the reason upon which it is based. May state or may not state the reason upon which it is based as per discretion of the members of the arbitral tribunal. What is the correct answer here? Yes, Jay, the answer is A, which is correct. They must state the reason upon which it is based. But do we have an exception here? Is there an exception that has been provided in law? The tribunal can skip stating the reason when the parties ask them specifically not to cite the reason, only when, which never happens in practically. Next question is, after the arbitral award is made, each party shall be delivered the original award, a signed copy of the award, a photocopy of the award, and unsigned copy of the award. What is the answer here? What would be the right answer? Please attempt this question. After the arbitral award is made, each party shall be delivered the original award, a signed copy of the award, a photocopy of the award, and unsigned copy of the award. What is the correct answer? I haven't received any answers from anyone. It's arbitral award and settlement agreement. Arbitral award is passed in arbitration proceedings and settlement agreement is passed in. Acha, you are talking about the difference in arbitral award and settlement award? What is your question, Shraddha? I didn't get your question. Settlement award is a type of arbitral award, which is when in between the arbitration proceedings only, the parties have amicably resolved their dispute or out of the arbitration resolved their dispute, and they request the arbitrator to record the settlement they have reached on. And that settlement, when it is recorded by the arbitrator, is called the settlement award. So settlement award is nothing but a type of arbitral award. Just the way we have final award, interim award, additional award, one of the type of arbitration award is the settlement award. Now coming back to the question. So after the arbitral award is made, each party shall be delivered a signed copy of the award. So the correct answer would be option B. Next question is, which of the following is the correct statement? An arbitral award can be inferred with if it is interfered with, if it is contrary to the substantive provisions of the Act or against the terms of the contract. An arbitral award can be set aside if the tribunal has not followed the mandatory procedure prescribed under the Act. An arbitral award can be set aside if it is contrary to fundamental policy of Indian law or the interest of India or justice or morality. Option D, all of the above. What is the correct answer to this one? Please attempt this question. Please attempt this question. So the correct option will be option D, all of the above. Next is, what is defined as voluntary, confidential, and flexible process by which the parties to a dispute seek to mutually settle their dispute with the assistance of a neutral third party? A, arbitration, B, conciliation, C, litigation, D is none of these. What is the answer to it? What is the answer to this? The correct answer would be B, conciliation. Next question is, the provisions related are contained in CPC, Arbitration and Conciliation Act, combination of both, none of these. The answer would be none of these. Yes, there is a mentioning of it, of mediation in the section 89 of CPC, but the provisions are not mentioned in detail. But yes, you can, I think the correct answer would be CPC, not Arbitration and Conciliation Act. Next question is, where the parties enter into a written agreement which contains a clause that any dispute that may arise between the parties in future shall be submitted to arbitration is termed as submission agreement, arbitration clause, conciliation, mediation. What is the correct answer for this one? The correct answer would be B, which is arbitration clause or the arbitration agreement. Next is an award given by the arbitral tribunal which disposes of all the issues submitted to arbitration is termed as A, B, C, D. A is settlement award, B is correction award, C is additional award, and D is final award. What would be the correct answer here? Yes, it is the next is Conciliation Act came into force with effect from 16th August 1996, 22nd August 1996, 15th August 1996, and 1st April 1996. What is the correct answer here? When did Arbitration and Conciliation Act came into force? It came into force on 22nd August 1996. Next, if an award made by the arbitral tribunal resolves one or more, but not all the issues submitted to arbitration, then the award is termed as. So the question is, if an award made by the arbitral tribunal resolves one or more, but not all the issues that is submitted to arbitration, then the award is termed as. Please submit your answers here. It is termed as the interim award. So the option B is the right answer. Which of the following is not a ADR? ADR stands for Alternative Dispute Resolution. So the options are Lok Adalat, Conciliation, Arbitration, and Litigation. So the correct answer here would be option D, which is litigation. Next question. Mr. Komal and Mr. Rajesh entered into arbitration agreement for the disputes that arise, if any, in their business transaction. Due to certain fault on the part of Mr. Rajesh, the dispute came before the arbitration for settlement. In the meantime, Mr. Komal dies. Mr. Rajesh shared off their liabilities on the plea that arbitration agreement has come to an end with the death of the other party. Decide the affirmative situation in the given situation. So the question arises, does an arbitration agreement comes to an end on the death of either of the party? What will be the right answer here? Does it come to an end? Does an arbitration come to an end on death of one of the parties to agreement? No, it doesn't get terminated. It remains enforceable by or against the legal representative of the deceased. So the correct option here will be option B. By the mere death of one of the parties, the arbitration agreement does not come to an end. The arbitration agreement termination points we have already discussed in the previous class. Now, next question is, Mr. X wants to start a bakery, so he contacts Mr. Y, confectioners and bakers, for supply of cakes and biscuits. The communication between the parties were over email. On one email, there was a term of service between the parties containing that any disputes regarding quality or delivery shall be submitted to arbitration conducted under the guidance of Indian Confectionery Manufacturers Association. Please place your orders if the above T&Cs are agreeable to you. X placed an order. So what has happened here? X, by placing the order, has agreed to the terms and conditions, because T&Cs specifically say, please place your order if the above term and condition are agreeable to you. Now state which statement is correct with respect to the arbitration agreement made between X and Y. Option A, it is not a valid agreement as the term of service is not contained in same document of agreement. It is not valid as the agreement is not laid down in particular format or formally. It is not valid as communication over email of the term of service is not proper. It is valid arbitration agreement in writing contained in correspondence between the parties over email. So what is the correct answer? It is a valid agreement, because arbitration agreement can be present over emails. It can be also be through reference to some other agreement. So because it was in writing, it is a valid agreement which has all the key components. Next is, what is the main purpose of Arbitration and Conciliation Act 1996? Option A, to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral award, as also to define the law relating to conciliation and for matters connected therewith or incidental thereto. Option B, to cover enforcement of domestic arbitration. Option C, to cover international commercial arbitration. Option D, to cover enforcement of foreign arbitral award. What is the correct answer to this question? The correct answer is option A, to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, conciliation, etc. Next question is, Mr. A, B, and C are partners in XYZ partnership firm. The firm made an agreement in writing to refer a dispute between them in business to an arbitrator. Now, in spite of this agreement, Mr. B files a suit against Mr. A and C relating to the dispute in a court. Examine on the admission of suit filed by Mr. B in the court in the light of Arbitration and Conciliation Act. Now, the options are, yes, it can be admitted by the court as the court has jurisdiction over the matter and overpowers arbitration agreement. Yes, it can be admitted by the court only in the case of challenge to the arbitral award in appeal. Yes, it can be admitted by the court if Mr. A and Mr. C mutually agree. No, it cannot be admitted by the court as the jurisdiction of court is ousted because of the existence of valid arbitration agreement. So what is the correct answer here? The correct answer would be option D, because the jurisdiction of court is ousted because of the existence of a valid arbitration agreement. Next question is, Milan Limited entered into an agreement with Vinay Limited for the supply of confectionery biscuits and cakes for a period of 5 years. The arbitration clause of the agreement states that all the disputes shall be submitted to arbitration after a period, it was found that the principal contract is invalid in the light of the Indian Contract Act. You are required to select the best option in the given scenario considering the provisions of the Arbitration and Conciliation Act. Now, what are the scenarios? Option A is the arbitration clause in the principal agreement also stands invalid due to the principal contract becoming invalid. Option B, arbitration clause is an independent agreement of the principal agreement and cannot be termed as invalid merely because the principal contract was invalid. Option C, arbitration clause shall be exercisable only if the judicial authority under the Arbitration and Conciliation Act allows to treat it as independent agreement. Option D, arbitration clause in the principal agreement stands valid only till the time principal contract was in force and valid. What is the correct answer here? The correct answer here would be option B, that the arbitration clause is independent of the principal agreement and cannot be treated as invalid. Here, the doctrine of separation comes into play. Okay. Next question is, in 2016, company Amar Food Processor Manufacturing Unit entered into a joint venture agreement with company Usha, the largest manufacturer of food processor, for supply of parts of mixer and grinder for manufacturing its latest model. Both the companies are registered under Companies Act 2013. Agreement carries the term that all disputes shall be arbitrated in Mumbai. State the type of arbitration agreement made between them. What will happen if the agreement does not have any clause relating to arbitration and dispute arose between them concerning quality of material supplied in 2017? Please attempt this question. What will be the answer to this question? Please attempt this question and put your answers in chat box. So the first question is, what is the type of arbitration agreement that is made between them? So here the type of agreement is a arbitration clause. It's a arbitration agreement. So when you talk about types of arbitration agreement, either it is an arbitration clause or it is a submission agreement. So submission agreement is for submitting a dispute which has already arisen between the parties. So let's say there is a dispute between party A and B. There is no arbitration clause in the contract, but both the parties A and B mutually agree to refer their dispute to arbitration. So such an agreement becomes the submission agreement. But here what is happening? The contract between the parties already provides that all the disputes will be arbitrated in Mumbai. So it is a valid arbitration clause. Second question is, what will happen if the agreement does not have a clause relating to arbitration and there is a dispute between them concerning quality of material? So option 1 is either both the parties, which is Amar Food Processor and Usha, they will jointly agree to refer their dispute for arbitration, or if they do not agree to refer their dispute to arbitration, they can reach out to the court for the resolution of their disputes. Correct? Is this clear? Next question is, how important are the ideas of independence and impartiality in arbitration? Is the arbitrator required to disclose anything to the parties? Yes, there are disclosures required as per section 12. Is membership of the same sport club as one of the parties problematic? It does not raise a necessary bias, but the bias can happen if the party is interacting with one of the parties to the dispute out of the way or promoting them or being partial. Next question is, can an arbitrator resign on their own account? Do they have to give reasons for their resignation? Could an award be challenged on the ground that the arbitrator had resigned without giving any proper justifications? The first answer would be yes, arbitrator can resign on their own account. It is his free will. Is it mandatory for him to give reasons for his resignation? No, it is not mandatory for him to give reasons. Can an award be challenged on the ground that the arbitrator had resigned? No, it is not a ground for challenging an award. Next question is, XYZ Company Limited entered into an agreement with PQR Company Limited for the supply of terrain tires to PQR for a period of 5 years. The agreement had referred to the terms and conditions contained in Indian Tire Manufacturing Association for sale and purchase of manufacturing tires. Clause 14 of the terms provided that if any dispute arise between the parties, the same shall be mutually decided by the parties or shall be referred for arbitration if the parties so determine. You are required to state whether the parties the agreement will be able to refer the dispute, if any, to the arbitration considering the given scenario. So the question arises whether there is a valid arbitration agreement. So if you read clause 14, it says, if any dispute arises between the parties, the same shall be mutually decided by the parties or shall be referred for arbitration if the parties so determine. So here, the consent of the parties to refer the dispute to arbitration is not clear. Where the consent is not clear, the willingness to participate in arbitration is not clear. In that case, it is not a valid arbitration agreement. Correct? Next question. Are we good till here, guys? By virtue of the arbitration agreement between Mr. C and P, a matter between them which could not be resolved smoothly was referred to arbitral tribunal having 3 arbitrators. 2 among the arbitrators were of the opinion that Mr. C has to pay a compensation of 2 crore to Mr. P. The 3rd arbitrator was of the opinion that Mr. P is not eligible to get any compensation from Mr. C. The award was then written and signed by the first 2 arbitrators, by the 3rd arbitrator refused to sign. The fact that the 3rd arbitrator refused to sign and the reason behind that was stated in the award. Mr. C contended that since all the arbitrators did not sign, the award is invalid. Now you decide it in the light of Arbitration Act. So tell me, is this arbitral award valid or invalid? Is it valid or invalid? It is a valid arbitral award. 1, the majority of the arbitrator has signed. The 3rd arbitrator who did not sign, the reason for which he did not sign had been recorded. Thus, it is a valid arbitral award. Last question that I have put in here for you. Shyam started a fresh juice shop and contacted Naresh for supply of fruits and vegetables. Most of the communication between them happened over email. On the email, they decided the payment terms and other conditions of services. For initial 5 months, Shyam was regular in making payment to Naresh for the fresh food, but later on stopped making payment. Naresh filed a suit against Shyam in magisterial court, but Shyam contended that the matter should be settled through arbitration. Referring to the provision of Arbitration and Conciliation Act, state whether the contention of Shyam is correct. So the contention of Shyam could be correct only when there was a valid arbitration agreement. The question does not say that there is a valid arbitration agreement between them. Yes, on the email, they have decided the payment, the terms and conditions of the service, but they did not decide on the arbitrability of the dispute. So in this case, it is valid on the part of Naresh to file the case in the court of law, right? So with this, we complete our class for today. And I hope all of you were able to have a good understanding on this chapter, which is Arbitration and Conciliation Act. From my end, I have discussed all the questions and queries that were put forward in front of class, and enough questions have been put. The questions that you see here are very much the questions that we have seen in past examination, and you can expect questions on these lines from this chapter. It's a basic topic. If you read it on your own, you will get through it. There's nothing too complicated about this. So I think with this, it's time to finish my class. Thank you, all of you, for paying attention. And I look forward to see you soon. Till then, all of you take care and stay safe.